Recent changes in Oklahoma workers' compensation change of physician law have made the issue more important for all parties. In many Oklahoma workers' compensation cases, the employer or insurance company selects the initial treating doctor. If the injured worker believes the doctor is not addressing the injury, is not providing appropriate treatment, or has released the worker too early, the worker may want a change of physician. The first change of physician is mandatory in many cases for work injuries covered by the Administrative Workers' Compensation Act. Oklahoma law provides that if the employer is not covered by a certified workplace medical plan, the employer selects the treating physician. Upon application by the employee, the Workers' Compensation Commission shall order one change of treating physician. When the application is granted, the employer must provide a list of 3 physicians from which the employee may select. Oklahoma's administrative rule similarly provides that a claimant seeking a change of treating physician or chiropractor for a work-related injury occurring on or after February 1, 2014, must file the Commission-prescribed application, and upon that application the Commission shall grant one change of treating physician or chiropractor. The rule also requires the employer to provide a list of 3 licensed physicians, one of which may be a chiropractor, qualified to treat the affected body part or condition. The 2026 Oklahoma Supreme Court decision changed the practical landscape. The major recent development is the Oklahoma Supreme Court's decision in St. Anthony v. Goodwin, decided February 3, 2026. The issue was whether Oklahoma law allowed more than one change of treating physician in a workers' compensation claim. The employer argued that the statute allowed only one change of physician per claim. The Court of Civil Appeals agreed with that position. The Oklahoma Supreme Court disagreed. It held that the law makes the first change of treating physician mandatory, but is silent about later change of physician requests. Because the statute does not limit the number of applications, changes per claim, or changes per body part, later requests are left to the administrative law judge's discretion. This is important because a worker may have more than one injured body part, may develop a consequential injury, or may need treatment from a different type of specialist as the case develops. Under St. Anthony v. Goodwin, the first change remains automatic when the statute applies, but later requests are not automatically barred merely because the worker already received a prior form of change. What the first change means for the first change of physician: the worker does not have to prove the doctor was wrong, biased, or unreasonable. The Oklahoma Supreme Court described the first application as automatic. The administrative law judge does not have discretion to deny the first qualifying request, and the employer may not object to the worker's entitlement to that first change. That does not mean the injured worker can pick any doctor in Oklahoma. The employer provides a list of 3 qualified physicians, and the worker selects from that list. The physician must be qualified to treat the affected body part or condition. Additional changes are different after the first change. Later requests are treated differently. The recent Supreme Court decision does not say every later request must be granted. Instead, it says the statute does not prohibit later requests. The administrative law judge may decide whether an additional change is appropriate based on the facts. This distinction matters. A later change of physician may require evidence showing why another physician is needed. For example, the treating doctor may refuse to treat an accepted body part, may release the worker despite continuing problems, may lack the right specialty, or a later consequential injury may require treatment from another physician. The worker should be prepared to explain why the additional change is necessary. Certified workplace medical plans have different procedures. The change of physician process may differ when the injured worker is covered by a certified workplace medical plan. The Court of Existing Claims explains that if the worker is not covered by a certified workplace medical plan, the worker is entitled to one change of physician for any affected body part upon application. If the worker is covered by a certified workplace medical plan, the worker may apply for a one-time change to another appropriate physician within the plan through the plan's dispute resolution process. This means the first question is often whether the employer uses a certified workplace medical plan. If it does, the worker may need to follow the plan's internal procedure before seeking court relief. The old 180-day and 2 change limits are not the same under the current Act. One source of confusion comes from older Oklahoma workers' compensation law. Before the 2013 reforms, the prior statute contained more detailed language about change of physician limits, including a 180-day treatment requirement for a body part and a maximum of 2 changes of physician per claim. The Oklahoma Supreme Court noted in St. Anthony v. Goodwin that this statute was repealed and replaced, and that those specific limitations are absent from the current statute applicable in that case. This is why older forms, older brochures, and older case law should be used carefully. Some materials still discuss the former workers' compensation system or the court of existing claims. For current cases, the statute and the 2026 decision should be reviewed before assuming there is a hard to change limit. Chiropractors may be included. Oklahoma's change of physician rule includes treating physicians and chiropractors. The current administrative rule states that one of the 3 listed providers may be a chiropractor, and each provider listed must be qualified to treat the affected body part or condition. This can matter in back, neck, shoulder, soft tissue, or musculoskeletal injury cases. However, the provider still must be appropriate for the injury and treatment needed. A chiropractic change may not be suitable for every workers' compensation injury. The parties can agree without fighting over the rule. The rule also makes clear that nothing prevents parties from agreeing on a change without strictly following the formal process. It also allows the parties to use mediation to resolve a request for change of physician. In practical terms, some change of physician disputes can be resolved by agreement. If both sides recognize that the current doctor is not appropriate, a negotiated change may save time and reduce litigation. Practical tips for injured workers: an injured worker should document why a change of physician is needed. This may include continuing pain, worsening symptoms, lack of testing, refusal to address an accepted body part, failure to provide treatment, premature release, lack of specialty care, or disagreement between medical opinions. The worker should keep copies of medical records, work restrictions, appointment notes, diagnostic reports, employer communications, and any records showing ongoing symptoms. The more clearly the problem is documented, the easier it may be to support a later discretionary change if the first automatic change has already been used. Talk to an Oklahoma workers' compensation attorney.